Ma'am, with your permission, may I start? A well-written memorial is a well-drafted memorial. Good afternoon to one and all. I, Naz Khan, on behalf of RSLW, take the privilege to start second National Moot Court Training Workshop 2003. The third session will follow up with drafting the memorial. The memorial is a document as important as speech before the judge. This is because, for judges, the moot court memorial represents the council's clarity on issues and objections. The memorial enhances the council's oral arguments as long as it is comprehensive, concise, and conceptualized. We have us Advocate Ishita Rawat, ma'am. Greetings to ma'am. We welcome you on behalf of RSLW. Ma'am is a senior associate at Vedanta Law Chamber, having a wide range of experience in the legal field, which is commendable. Her expertise in client meetings and drafting moot court papers, and she also assists client during negotiation. Ma'am has 7 years of valuable experience, specialized in the area of commercial laws, criminal laws, and other area of laws. Before beginning the session, participant please note, keep your video off and audio on mute. At the end of the session, all participants are requested to fill up the feedback form. Certificates will be provided to those who will fill up the feedback form. In case of any misconduct, the participant can be disqualified from the workshop. Now, I would request Ishita ma'am to please commence the session.
All right. Thank you so much for the lovely introduction. So first of all, good afternoon, everyone. So as Naz correctly stated, so today what we are going to deal with, the drafting of the moot court memorial. So for drafting of the moot court memorial, first, all of you really need to understand what is drafting. So for that, it should be really clear to all of you what is the purpose of drafting and why are we drafting the moot court memorial and what is the importance of drafting of the memorial, right? So I hope that nobody understands drafting as typically as writing something on the laptop or your computer, right? So it is basically structuring and organizing all the information that you have, which also ensures clarity and also ensures precision, the way you're presenting your case and the way you're presenting your moot, right? So for that, we really need to understand and also why the drafting is very important for all of you, not just as budding lawyers, as law students, but also for your future. Maybe you may be litigating in some courts, or you may be in some corporate field, or you may be indulgent in judiciary. So for that, drafting plays a major role. See, drafting is basically your pleadings. So the pleadings, they are of utmost value and of importance of how you present it before the court, right? How you present it before the moot court also, and how you present it before any forum. So you need to understand that the pleadings, you cannot go beyond your pleadings. And now for your drafting, you cannot go beyond your memorial, right? The only thing which you can go beyond your memorial is basically any case laws that you refer or any sections or any law you discuss. So that can go beyond your memorial, but you cannot state any extra facts, any extra arguments beyond your memorial. So you need to understand, everybody needs to understand the importance of a well.
Ma'am, we can't hear you.
Am I audible now?
Yes, ma'am.
Okay. So I understand that in your session 2, you were dealing with mooting and research. Okay. So now what we'll be dealing is that how you have to draft your memorial and the way that your memorial should be and how it has to be presented before the moot court and what importance it is there, and it would take place in your for you to present your moot court problem also and for your arguments also. All right. So basically, you have to understand that a moot code consists of several contents which have to be precisely stated in your memorial. Firstly comes the cover page, right? So the cover page is basically the front page of your memorial. Okay, so that should be very clear. See, the cover page is equivalent. So whenever you file a petition also before a court, see, I'm a litigating lawyer, so I can also help you. Otherwise, also if you want to litigate in future, so I can guide you in that way also. So what we understand by this is that it is basically the cause title. It is basically the front page of your memorial, right? So now I hope that if anybody would have been participating in moot courts earlier, so the blue color would is for the petitioner or the applicant or the appellant, and the red color is for the respondent, right? So you have to really understand, you have to take care that whenever you submit your moot memorial, so it should be in that way. The cover page should be that way: blue for the petitioner or the appellant, and red for the respondent. Also, importantly, it also differs from rules to rules and from the moot rules, whatever that you get. So it is very important that you read the rule book very properly and you read it again. And also for drafting, it is particularly important that you read your moot problem again and again. Just don't read it once. You may feel like you've understood the problem, but then if you read it again, you might find that, okay, you found something new, right? So first and foremost thing, before starting the drafting of the memorial, just go through the moot problem at least 5 to 6 times. You might find new laws, you might find something new that come out of it, right? So then read it thoroughly, read it carefully before you start with the drafting, all right? And also read the rules. So the rules and also the format that I'm telling you for the drafting of your memorial, it would be subject to the rules that you would get for your moot court problem and for your moot court memorial, right? But then otherwise, the generally practiced memorial, I can guide you with the way that it has to be drafted. All right. So the first thing what we were discussing earlier is your cover page. Okay. So it is basically the front page, as I told you. What would it consist of? It would consist of your moot court competition name, right? The court before which the parties that are appearing, right? And then it would consist of the name of the parties, and then it would also consist of your moot code, whatever code that you would getting, or all the necessary detail, right? So for that you also have to remember. So okay, so in case it is an appeal, so you have to write the appeal name, appeal, and the number and the title of the appeal. So if it is a writ petition, you have to write it as a writ petition and number, and the title would come and it would fall. So in this way, your cover page would be made. All right. So now secondly, it would come the table of contents. You have to remember the table of contents. It would be really helpful not for you, but for the reader who's reading your moot memorial, right? So it should be very clear, and technically it is made in the last. So for that, you have to understand that how your table of contents is made, and you have to basically showcase it in a way that the reader or the judge, whomsoever, you can just have a quick scan of your moot problem and of your moot contents, right? Your memorial contents, it should be visible by the contents of your table. Okay. So second is the table of contents. So you have to basically it would be just the outline of your whole memorial. Okay. So technically it has to be made in the last, but however, you have to take care that from that table of contents, the reader or whomsoever the judge quickly understands what your memorial consists of. All right. So now the third, it would come the list of abbreviations. We all understand what is abbreviations. They are basically short forms of whatever, of any term that we use. But you have to remember that it also has to be technically made in the last, because whenever you're drafting your memorial, so you are drafting it the whole way you're drafting your memorial, you might use abbreviations at various places. You have to take a note of that, and you have to include it in your list of abbreviations. Okay, it would also consist of the footnoting, any footnoting that you do. Say, for example, you're referring to a case name, right? So you're referring to a case name, say XYZ versus ABC, right? And where it is reported in SCC, it is reported in AIR. So AIR abbreviation, you have to state that AIR stands for All India Reporter. Okay, so anyway, you state a number, you say NO, so you have to explain it. Okay, NO, it stands for number, NUMBER, right? Or otherwise, see, it would go on. So like for paragraph, you use para word. So you can explain in the list of abbreviation. Okay, para means paragraph. So this is the way the list of abbreviations would go. And please try to include everything in your list of abbreviations. And also just don't make your memorial messy by only stating abbreviations again and again. Okay. So do not state abbreviations unnecessarily. make your memorial look very neat, make it look very simple to read. You do not have to use very fancy words that you yourself don't understand when you present the memorial and you present your arguments before the judge. So make the memorial in a way that you should be through with the memorial and you should know that what it contains of, and so accordingly you can present before the forum, before the moot court, right? So now next comes the index of the authorities. Okay, so this index of authorities, it is basically the bibliography, right? It consists of the list of the cases that you're citing, all the books or the reports or the statutes that you're referring to. So all this would be included in your list of authorities. This is a table of authorities that you would be stating. Even if now sometimes the moot court students also have the name of the website that they're referring to. So you also have to state that where did you fetch the said information from, when did you last assess the website. So the list goes on, right? So now, and the next would be the statement of jurisdiction. Okay, so basically you really need to understand this. Now, basically even the petitioner who's presenting the case and even the respondent basically who's opposing the case, they have to really understand the statement of jurisdiction. So what is it? Basically, you decide that, okay, so it is basically the proclamation of this jurisdiction, basically the court that you're appearing in. You have to state that why we are appearing before a particular court and why the jurisdiction of this court is there for the applicants or for the applicant of the petitioner that they're presenting the case before a particular forum. So for that you need to basically state the jurisdiction. Also, you can state the maintainability of the jurisdiction, right? So okay, so if I'm appearing from the respondent side, if I'm opposing the case, I can very well in the statement of jurisdiction I can state that so and so such and such case is not maintainable before this honorable court because of so and so reason. Okay, so the statement of jurisdiction, it would basically contain of such thing, and accordingly you can present it in a way, and you can present that how a petitioner can present that how the particular case is maintainable before the forum, and the respondent can very well rebut it in the statement of jurisdiction. Okay, so now the next stage comes as the synopsis, the statement of the facts. So you really need to understand. So what I have noticed in my tenure of 7 years, like how whenever I have basically judged a moot court competition also, some students, what they do is they just verbatimly, they just write the moot court problem in the statement of facts. However, I would suggest all of you not to do that. It gives a really wrong impression to the judges and to the reader, whomsoever is reading your moot court memorial. You need to understand that statement of facts is not basically verbatimly that you're stating the facts, right? You can very well, basically come with a different line of facts. See, facts cannot change. Let's face it. Whatever facts that are given to you in the form of the moot court problem, they won't change. But the way that you present it in your memorial, it can very well, you can vary from the moot court problem, right? So then make it in a way that it should be precise. It should be clear. So for a judge, the judge do not have to read the problem. By reading your statement of facts, it should be clear to the viewer, it should be clear to the reader. So what you're going to state in your memorial, now what are the facts? So those should be precise. It is a good practice basically that you state your own facts, you state it in a way that it is very beautifully, it is communicated to the viewer, to the reader, that what you want, that what you are stating in your problem and what your arguments would be advanced and what would be the facts of the case, right? So it should be relevant, it should not be very, very lengthy, and it should not be verbatim of the moot court problem. All right. So now the next would be the summary of your arguments. So it is a very essential core of stating like what your arguments would be leveled on, how you would be stating your arguments. So ultimate purpose of the memorial is basically to argue. It is to basically to submit your arguments, right? So the summary would be like you're stating your issue. So after the statement of facts would be the statement of issues first, right? So issues are basically the questions and whatever you're putting to the court or whatever, it should be precise and relevant. They are definitely they are stating the contention of the preposition of the moot court problem. Okay. So I just got a message that I'm going too fast. I'll just go a little slow. I'll quickly explain whatever we have done till now. What we covered till now is firstly the cover page. that has to be dealt with. Now, how it has to be presented, that is the front page of the memorial. Okay, I hope everybody is following me till that. And then second would be the table of the contents. Basically, it is sort of an index what your moot problem would consist of. If anybody wants to make notes, please go ahead and make notes. And if anybody has a question, so then we can take it up later. Okay, so this table of contents, it would allow the reader to quickly have a scan of the memorial. So basically, this is the agenda behind the table of contents. Okay, now the third is the list of abbreviations. It is basically an important part. It comes in the end. That basically it is drafted in the end. However, it comes after the table of contents. Therein you can state whatever abbreviations that you're using in your memorial, it would consist that and the explanation and the full form of the abbreviation. All right. Now, fourthly, would be the index of the authorities, would be the table of the authority. It would be of any case law that you're submitting, any report, any book, any statute that you're referring to. It would be consisting of that. Okay. So I hope everybody is clear for these 4 points. Now, fifth would be the statement of the jurisdiction. It is basically the jurisdiction that the court you're presenting it before, and on the maintainability, how the petitioner would definitely submit that how a particular problem and how a particular case is maintainable before the court, and the respondent can very well submit a rebuttal that how it is not maintainable and would can. Okay, somebody raise their hand. Shall I continue?
Yes, ma'am.
Okay. Thank you. So, okay. So now, thereafter, it comes as to the statement of the facts. It basically it states, and as I explained earlier also, it does not just state verbatim the problem. Please do not state the problem itself. You have to explain what according to you are the facts of the case. You can narrate it in your own way, but you have to be precise and you have to state relevant facts. It should demonstrate some quality from your end. It should not be verbatim of the moot court problem, right? So till now, I have covered these 6 topics. I hope everybody is clear with how the drafting of the memorial should be. Okay. So now, moving ahead, we will move ahead with the statement of the issues. Okay. So issues are basically the issues that you raise, basically your contentions, the proposition that you're mentioning, and that which you will explain in your arguments. Okay. So for example, I would say, before any court, if I take a civil court matter, and if it is a recovery of money suit, okay. So what would be the issues in that? The issue would be whether the respondent is liable to pay, say, 5 lakh amount to the plaintiff or not. First, secondly, whether the suit that has been filed, it has been filed within limitation or not. So see, the issues, they would be framed in that manner, and subsequently you have to answer those issues in your arguments. Okay, so this is basically how you're approaching your case. That would be dealt in your issues. Okay, I hope I'm clear. And if anybody has any question, I'll be happy to answer that. Okay, so now moving on. Now, as we dealt with, now comes the summary of your arguments. Okay, summary of your arguments is basically for every issue, but only in brief. It is only a summary that the issues that were raised, and this is the argument summary that I'll be stating. So it does not have to be lengthy. It would come subsequently. So you have to state what your arguments are going to be. Okay, so which are also essential because that is the ultimate purpose of your memorial. All right. So those are the summary of your arguments. Okay. So thereafter comes the arguments advanced. See, let's face it, the moot memorial is basically based on the argument advanced. It is the most important aspect of your memorial. It has to be drafted in a very importantly and very precisely. It should state all your arguments in a precision that is understood by the judges. See, what mistake that we do as students also, that what we do is we focus on the arguments that we'll be arguing before the moot court, right? But many of us forget the importance of drafting of a memorial, which is equally important as is arguing before the moot court. Okay, so for that, your moot memorial, it should be strong enough, right? So even if we just miss some point, so we can quickly refer to a memorial and we can just quickly advance such arguments as well, right? So for that, a proper research of your problem, a proper research is very important. I hope everybody has dealt with that in the previous session, but I will also explain it to you. Why is it important? Is because your research, it shows in the memorial. All right. Or the viewer, the reader, the judge would very well understand how well you've researched, and that would show in your memorial. So for that, a careful drafting of a memorial is a must, because of for which you should properly read your problem. You should properly read the rules. See, you have to stick to the rules. Okay, the whatever the points that I'm telling you, like the way it has to be basically in this erratum, it has to be drafted is actually the basic, the general memorial principle that we follow. However, the rules, it can differ, right, from a moot court competition to another competition. Okay, so I'm sure that you as budding lawyers would be wanting to basically argue and to basically present your moot problems, and I'm telling you that it would be really helpful for you in future. Maybe you may be litigating, or you may be in some corporate sector as well, but it is really important for you to boost your confidence, to increase your argumentative skills even with your clients. So in every which manner, your this should also be reflected in your drafting of your memorial. Your memorial should speak for itself. So this is why this drafting of memorial is a very important aspect, which, let's face it, some of us we might miss, because sometimes what happens is the memorial submission deadline is earlier, and so we basically just type something and we just basically just submit it. No, it should not be the case. As I told you, you cannot go beyond your pleadings. Okay, what you can state beyond your pleadings is just the case law that you're referring to, or any law point, or any law that you're referring to. You cannot go beyond your memorial otherwise. Okay, so your memorial should speak for itself. It should be precise. It should be it should show the research that you've carried on. Okay, I won't get into the research part as we've already dealt with. Okay, now, so coming to the argument advanced, it is basically the detailed explanation of each of your issue raised. For example, you're explaining and supporting your issue. So this would be supported by the case laws that you're referring to, right? And all the other reports, the statutes that you're referring to, the facts they are referring to. The more you put the legal cases in your arguments advanced, the more it would strengthen your memorial and your case, right? So it is very important that you do a careful and a detailed research. You research for cases, you research for statutes, in which provision the case you can win a case, which provision should be used, right? So it is very important for you for a careful research. This is important for the arguments advanced. You basically have to state, but also importantly, it should be structural. It should be focused. Okay, it should not be messy, and you have to particularly state the properly that whatever you want to mention. Okay, so now then lastly comes the prayer clause. Prayer is basically what you're seeking from the court. It is basically the relief that we say, that what we are wanting, what do we want from the court. Okay, prayer, it should be clear. You should, first of all, you should know that what you're seeking from the court, what is the relief that you want. Is that what your prayer would consist of? Importantly, what happens in my personal experience as well, many judges, like due to paucity of time, as we know, like in High Court also, whenever we are arguing, so say a judge does not have so much of time to go through the whole pleadings, the judge quickly opens the prayer clause and sees that what relief that you're referring. Sometimes you may be arguing something more than what we have pleaded in our case. The judge would quickly say, but it is not stated in your prayer, right? So you have to be very careful in drafting the prayer clause as well. So I hope that the contents, like how the moot memorial has to be drafted, is understood by you all. I would also state some other contents also that are very important for drafting a memorial. So for that, the other contents basically is the header. Every page of your memorial, it should consist of the competition name. It should consist of the title of the case. The page numbering should be proper, right? Page numbering should be really proper. You should properly cite everything that you're stating. Any case law that you are reproducing, it has to be carefully, it should be cited, and the citation should be proper. Many times what we do is that we take a case from, say, India Qanun, and then we just quickly just mention it. No, that is not the correct way. You have to particularly follow the proper citation guidelines. You have to, again, I'm telling you this, repeating this again to you, you have to see the rules also of your moot court competition. Okay. Now, other thing, what is important is footnoting. Footnoting is of utmost important. Okay. Footnoting, it shows that how much research that you have put into and how your drafting is. It must speak for itself, right? So basically, the general footnoting that is followed, it is Blue Book 19 edition that we generally follow for footnoting. You can also use according to your rules. Again, I would say, but generally you can follow the Blue Book footnoting, right? So now, also, if you're reproducing one more case, I hope everybody is aware of the term supra of IBID. You can use such terms. It would make your memorial and make your basically drafting look very clear, look very neat, look very intelligent. Okay. I emphasize on this fact that your drafting should be really intelligent. It should show what you're seeking from the court. It should show what you're pleading. It should show that whatever the problem that you're clear about, and you know what you're stating before the court or before any forum. Okay. So for that, it is really important that it is clear and precise and neat. So for the neat part, I would say the formatting is very important of your moot memorial. Okay. You do not just simply write everything in a running sort of a way. It should be properly numbered. It should be properly segregated, and you should use caps for the headings. For subheadings, you can use 1, 1.1, and 1.11, but then it should be segregated in a manner that it is clear to the judge, to the reader, that what you're stating. Okay. Whatever laws that you find applicable, do mention them. Find any disputed points that are there in your moot court problem, and then just put it in a way that it is crystal clear to whatever that we are submitting to. Okay. Also, I would again say that after your research work is very important before drafting of the memorial. So what you can also do, that maintain uniformity in your memorial. Okay. Because of which your moot memorial would also look very tidy and beautiful. Okay. Well, it does not mean that you have to attach any pictures to it, but it also includes that you're spacing it properly, you're using proper formatting. If there are any formatting guidelines, you adhere to it. If not, it should be clear. It should be clearly visible. It should be legible. It should be margined properly. Okay. So also, I would say that a bad formatting, really, it takes the judges not notice on the contents, but notice on the formatting. Okay. So formatting is, according to me, a very important thing. Formatted in a way that it is very clear, and you use the font size properly. Use the general, if there is any general font size, then you can, or font name, so you can use it accordingly. There are many Times New Roman is there, Bookman Old Style is there. This is basically what we use in courts. But then for you, I'm sure that the rule book, it would contain the formatting and the font size and the size and the spaces also. Okay, so kindly adhere to it and kindly present in that manner, I would say. And okay, so basically, I would say that I'm done with the explanation of the drafting of the memorial. If there is any question, then I think we can quickly take questions.
Participants can unmute themselves and ask the questions.
Hello, ma'am.
Hello, yes.
Actually, I wanted to ask this question that
Yes.
this table of authority and bibliography is same because it also contains a list of statute, books, articles that to be referred.
Yes, it is basically the same thing. It is basically the bibliography only, but we term it as the table of authorities. Okay, so for better clarity, in wherein, as I stated, you can state all the statutes and all the reports, and you cited any books that you can mention in the table of authorities. Okay.
Okay, ma'am. Thank you, ma'am.
Okay, no problem, Kanishka.
Good afternoon, ma'am.
Hi, good afternoon. I cannot hear you.
Ma'am, that you talk about synopsis. Ma'am, what is the actually
Right.
meaning of synopsis?
Okay, synopsis is basically the brief, right? The brief of your memorial. And the brief, see, brief of your memorial, it is the brief of the facts that you're stating before the moot court. Okay. See, you have to understand. So, synopsis, when you're presenting a case before a court, is different, and synopsis of facts is different, right? Synopsis is basically the brief of your whole of your drafting. Okay. But synopsis of facts is the brief, you're stating the facts in brief before the court. Okay. So, this is the difference. What we say, we can state it as statement of facts also in the memorial, and we can also state it as synopsis of facts. Facts in brief, basically.
Okay, ma'am. Thank you, ma'am.
No problem. Thank you. Any other question? There was a question written as how can I make a memorial good for moot court competition? Okay, so for that I would say that please stick to the rules that you have to adhere to. Carefully adhere to the same, and make it look very precise, and it should be very clear. So do not use too much of fancy words that you yourself don't understand that I was saying. But you should be pretty concise, and it should basically be supported by various case laws, by statutes, by other reports, right? So make it in a way that it is understood by the judge properly, okay? And you have to stick to the moot court problem. Be precise, be state something quality, state all the things that I told you. Follow the format that I told you, right? The cover page, the list of abbreviations. I hope that whomsoever is asking me the question wrote the contents, right? The moot memorial would consist of. Okay. Yeah. Any other question?
Hello, ma'am.
Why? Yes. Hello.
Yes, ma'am. Ma'am, I wanted to know in a memorial, when we cite
Mhm.
case laws, is it
Yes.
important for us to put the statement, the facts, or is it that we have to just only put the verdicts which is held?
I did not get you. See, in statement of facts, we do not write case laws. I'm sorry, but then please repeat your question. What do you
No,
want
ma'am.
to exactly say?
I
Yeah.
mean to say that
Mm.
in memorial, when we cite case laws,
Mhm.
in case laws, it is important for us to put the facts.
No. It is not important for you to put facts in the case laws. No, please don't do that. See, the facts would be really different. A case to case, see, no facts can be same in two cases, right? Right. So we do not have to state the facts. Yeah. Please do not
I
state
can
facts.
just
Huh?
I can just put the verdict, right, ma'am?
You do not need to put the verdict also in the whole, right? Just put the part that is related to your case, that will strengthen your case, okay? That is supporting your case. Do not put anything that would go against your case, okay?
We can put held and the so and so Supreme Court judgment and all.
Correct. You can also put your own language, but then just don't quote it, okay? So see, okay, everybody, you must understand this. This is a very basic thing, but then sometimes we miss it. So what happens is that, okay, so I am stating a Supreme Court case, okay? Right. So what will I do? I'll just put it like, okay, so in this case, so and so case reported at so and so held. If I am reproducing, right, the paragraph of the Supreme Court case, it has to be quoted. Okay, it has to be quoted, like in inverted marks. Okay, but if I'm putting it in my language, it would be like held that so and so, so and so. Understood? I hope everybody is getting me here.
Yes,
Okay.
ma'am. Thank you, ma'am.
Okay, no problem here.
Excuse me, ma'am.
Yes.
Ma'am, do we have to add the details in the prayer, or do we have to just add a gist of what we wrote in the memo?
No, you do not have to write the gist of your memorial. See, I think if you understood my point, I was stating that in the prayer, you have to just state the relief that you're seeking. What? See, if there is a moot court problem, okay, you're seeking, so I'm from the respondent side, okay, I do not want this problem to survive. I do not want this case to survive. What relief would I seek from the court? You tell me, what relief would you seek from the court? What relief would you seek? I'm asking you. you would see that you want this so and so problem to be quashed, right? You want this case, you want this case to be quashed and set aside. You would want the to impose cost on the other side. You would want this problem to be dismissed, right? So these are the
Yes,
prayers
ma'am.
that you would raise, okay? And if I'm the petitioner, if I'm the one presenting my case, what will I state? I will state to kindly allow my petition, okay? To kindly grant me so and so thing, okay? So and so whatever prayer that you're seeking before the court, okay? And to kindly give me, see, we can also add to kindly provide me advocate cost. This is what we state before the courts also, okay? And for any other release that this court may deem fit and proper. Right? So this is what we state. What we state is that the relief that we are praying for the court to grant us, okay? It do not consist of a moot court memorial, right? Do not do this mistake. It has to be pretty precise. It has to be in points. It has to be not more than one sentence. Okay, you will understand it when you draft it, but then you have to draft it. That's why I'm telling you. So the research work is also very important before drafting. Just do not just start from the drafting of the memorial. Research well, right? Before you start drafting, okay? Remember these points that I told you while researching, okay? And then just put them there, right? The table of contents and the list of abbreviations that I was referring to, right? You have to basically make it in a way that it is clear for the judge to understand what your moot memorial consists of, okay? I hope I've answered your question.
Thank you so. Thank
Okay.
you so much,
You're welcome.
ma'am.
You're welcome. Anybody else?
Good afternoon, ma'am. I would like to
Hi, good afternoon.
one question.
Yes.
Why should it is needed to put abbreviation in the memorial?
Why is it important? See, it is important because you cannot just write each and everything again and again. Okay, so it shows, it makes your memorial look very neat. All right, and it also helps the viewer. See, it helps in not. It helps in avoiding repetitions. Is why we use abbreviations. But also that I also added. If you heard my lecture properly, so I also added that you do not just use abbreviations again and again. Okay, but then you have to basically, right, you have to explain. See, AIR, as I said, okay, what is AIR? It is All India Reporter, okay. What is SEC? SEC is Supreme Court cases, okay. So all these citations that you're using, these citations you will not use it at Supreme Court cases, so and so. You will obviously use the abbreviations, right? But then for your memorial to speak for itself, as I stated, you can very well state that SEC stands for this, AIR stands for this, number stands for number. It makes your memorial look really, basically attractive. Which is why I feel list of abbreviations is also a good point that you can basically make the judge feel that the participant, the contestant, or whomsoever the student is really prepared. Okay, and he has done his or her job pretty well. So this is why. And basically it is to avoid repetition also, which does not mean that you everywhere use it. See, for example, we use petitioner. Okay, so petitioner's name is say Ishita. Okay, so Ishita is going there, Ishita is going there. I would not state that. I would say hereinafter referred to as a petitioner. Okay, so for example, I'm stating for XYZ person. So we can also creatively use abbreviations according to us. It has to be done very intelligently. Once you start drafting, you'll understand it. Basically, it is to avoid repetition. Okay.
Okay, ma'am. Thank you.
Okay. Yeah. Anybody else?
Ma'am, I have a question.
Yes, please.
Ma'am, can you please give some information that how should we prepare a prayer?
Prepare your prayer. Okay. Okay. Right. See, basically, okay, as I told you, see, okay, so all of you have to really understand. All of you understand what is the difference between a petitioner and an appellant? Do everybody understands? Please, anybody answer it. It would really help me to basically make you guys understand. Anybody? What is the difference between a petitioner and an appellant?
Yes, ma'am.
Tell me.
Petitioner वो होते हैं जो केस फाइल करते हैं और apparent
Appellant क्या होता है? Yes.
वो होते हैं जिसके अगेंस्ट केस फाइल की गई होती है.
No.
मैम
Anybody else?
appellant is those जो है ना जो लोअर कोर्ट ने जो भी judgment दी है उससे satisfied नहीं होते, and which is why they appeal to higher court.
Correct. And what is the petitioner?
Who files the case? Who files the petition related to it?
Who filed a petition? Correct. Who was it? Who answered my question? Kanishka. Very good, Kanishka. Okay. So basically, what she is stating is correct. See, we really have to understand this. Your mood problem, it can be any appeal also. Okay. We have to understand appeal sounds familiar, right? It is an appeal. Appeal, where does it come from? It comes from a lower court. There is any decision that you're aggrieved of and you're appealing it. So you are the appellant. Okay. This is the appellant, as she correctly mentioned. Okay. Who's a petitioner? Petitioner is who's filing a petition. Okay. So that person is a petitioner. And who's a plaintiff? Can anybody tell me? Who's a plaintiff?
Ma'am, whose right has been violated? Legal rights have been violated.
See, everybody's right is, Kanishka, everybody's right is getting violated now. Whomsoever has come before a court. So that's fine. But then who is a plaintiff? Like, why do we use the term plaintiff? And where is it used? Has it ever occurred to you that why different terms are used? Why plaintiff? Why petitioner? Why appellant? So this is what she was also stating. Anybody else?
In my opinion, actually, plaintiff is about consideration. Who takes consideration? It is generally used in law of torts, like.
No. Okay.
So plaintiff is used in civil cases.
Who was it? Very good. Pooja. Very good. Okay. So basically it is used in suits. Okay. It is used in suits. For suits, we use plaintiff term. Okay. And for the respondent side, we use defendant. That is the plaintiff and the defendant. Okay. Very good, Pooja. So for the suits, we use plaintiff. For the base case, for the civil matters, we use plaintiff, as she correctly stated. For petitioner, we state any petition that is there. It can be a writ petition. It can be any petition. It can be a revision petition. It can be a review petition. It can be a XYZ petition. Okay, for that we use petitioner word. And for appellant, we use it if it is an appeal from the lower court to the higher court. Okay, so I hope that is clear. So firstly, we need to be clear, like who are the parties. So for the front page also, okay. So for that basics that you really need to understand. This is how you would also frame your front page, okay? The cover page that I am stating. The color, the blue and the red part is, I think that you guys know, and that would be also covered in your rules, okay? But you really need to understand that the cover page is really important because you will be mentioning the parties that you're representing, okay? So how it is done. So we state the moot court competition name. We state the forum that we are entering into, the forum that it has been filed. Say, hypothetically, it is filed before High Court. So we would mention in the High Court of Judicature for Rajasthan at Jaipur, bench Jaipur. We are sitting in Jaipur, so Jaipur, bench Jaipur. Okay. So then we'll mention the number of the case. If it is an appeal, so appeal number dash and the year of the case. Okay. So and then we will mention the name of the parties. That is the title of the parties. ABC, who's the ABC? Petitioner versus who the case is filed against. The respondent, say XYZ, is the respondent. Okay. If in case it is a plaintiff, ABC, plaintiff in right hand side versus XYZ, defendant. Okay. So this is how your cover page is drafted. I hope it is clear about the cover page. Now, coming to your question, somebody asked, how do we find format or draft your prayer? Okay. Prayer is what you're seeking from the court, that your relief that you're seeking for the court. What do you want from the court? It would be basically consisting on your moot memorial, what you're seeking from the court. Say what you're seeking is, as an example that I gave, was of recovery of money suit. If it is a suit, then who would be the parties? Plaintiff and the defendant. Okay, say I'm the defendant. I filed the suit. What am I asking? What relief I'm stating? First of all, first relief would be to allow my petition. Okay. First would be to allow my suit. Okay. I'll just correct myself. If we are going by my example, I'll just tell you the sort of the prayer clause, how it would be drafted. Okay. Firstly, it would be to allow my suit. Secondly, to allow me the 5 lakh rupees with, you can also seek for interest, with interest at so and so percentage, right? From the date of when the amount was due till the payment. Okay. So the interest part, you can very well, you can mix it and you can make it in a way that your moot problem is also referred and how your mood problem is, so it has to be drafted accordingly, right? You can also seek compensation. You can seek compensation for damages. Okay, you can seek from the court, get the compensation. You can seek for any mental injury, whatever that you stated in your moot court problem. But the problem, the arguments advanced should also consist of the basically the in detail of the same, right? And lastly, you would state for any other relief that this court may deem fit and proper. So this way, the the prayer of the suit it can be filed. Also, you have to understand. So this is so right now we'll just stick to the moot memorial. Okay, what I'm telling you is in an advanced stage. If in future anybody would be litigating and would be filing a case before any court. Okay, so for that you need to understand it is basically all the relief that you're seeking before the court, before your judges. The relief that you stated, it has to be stated. Does not have to be really detailed. Does not have to state of your memorial contents. It has to be precise. It does not have to be so precise that you're not like properly stating what relief you're seeking. It can be in a para, right? But it has to be precise. It has to be technically stating what you're seeking. Say you're seeking. So if it is a family court matter, if it is a family court problem, so the relief would also basically be accordingly, right? So, but it does not have to contain the whole memorial part. I hope I'm clear to you guys. Any other question?
Good morning, ma'am.
Hi, good afternoon.
Ma'am, if there are two parties from the respondent side who are appealing in higher court, so whose name will be written in the cover page? Whether it will be ABC and others or just ABC?
Okay, okay. Like it's a good question. See, so we really have to understand. Okay, so there were two respondents in the lower court that you're saying, right? As I've understood from your problem. And those two respondents, they are appealing before the higher court, right?
Yes, ma'am.
Both of them are appealing, na? So
Yes.
both the parties would be in the area of the appellants. It would state both the parties' name, and on right hand side it would be appellants instead of appellant versus the basically the petitioner that was there before the lower court. It would be stated versus the petitioner's name. So you really need to understand. So in any appeal that you're filing before any forum, and even if you're memorial that there comes an appeal, so it has to be understood that the cover page, it does not change. Like the name of the parties would be same. See, it would be versus would be reversed, okay? But then you cannot change your cover page. Yeah, the cause title never changes. So for courts also, we cannot change our cause title. The cause title has to remain the same. The parties, of course, the respondent has become the appellant, so that would be changed. The serial would be changed, but other contents have to be the same. Okay.
So, ma'am,
I hope I'm clear to you.
first the appellant name will come and then
Versus the yes.
Okay, ma'am. Thank you.
Okay, you're welcome, Karan. Yes, anybody
Ma'am.
else?
Ma'am,
Yes.
is there any role of evidence in memorial?
Role of evidence. See, role of evidence. See, it would really depend on the moot court problem, right? You cannot just state role of evidence. See, it really depends. Your moot problem is say it is a civil matter. So, what evidence would any role there would be of any evidence? So in moot memorial, I don't think that you really have to be stating any evidence. And how will you state? Can you just give me an example, like why this question has come across your mind? I'm
Ma'am, like
asking you.
in criminal cases, if there is any statement of a character is mentioned, then can we
Mhm.
state them in memorial?
Yes, you can. You can. In your arguments, you can. You can. But then just don't make it in a way that it would look little foolish. Okay, you can just state it briefly. I would suggest. Okay.
Okay, ma'am. Thank you.
Okay. Anybody else?
Ma'am, if the issues are already stated in the browser, then can we add mentability of suit if it is not given already in the issues by the organizer? At the first of the
Definitely. You can state regarding the maintainability in your statement of jurisdiction. Correct. You can do that. Anybody else? I hope everybody is understanding. See, do not confuse it with the way the cases is filed before a court, okay? But then for your understanding, I'm telling you, a moot memorial can also be drafted in that way. But you do have to take note of the rules that you're given, okay? You have to take care of the problem that you're given, okay? Read the problem properly, understand the jurisdiction. The person who's presenting the case has to understand and has to adhere by the jurisdiction. So you have to base your moot memorial in a way that will strengthen the jurisdiction. And for the respondent who's opposing the memorial, okay, has to basically drafted in a manner that you can also oppose the jurisdiction. It is not entirely necessary that you have to negate the jurisdiction, okay? There should be some point, there should be some maintainability point also. So you have to come for that point. So you have to be really good in your drafting to oppose the maintainability, okay? So you have to be really thorough with the problem. You have to be really thorough with your research. As I would state before you. Anybody else?
Excuse me, ma'am. Good afternoon, ma'am.
Hi, good afternoon. Yes.
मैम ये बताओ आप annexure is the important part of the moot court or नहीं?
Annexure or the case laws that you'll be referring to, or annexures, you're saying. Can you just come again?
Annexure जो मतलब आप केसेस के एविडेंस वगैरह आप डालते हो तो उसकी मैं बात कर रहा हूँ. Evidence.
See, you have to understand. You really have to stick to your moot problem also. Okay, just don't go really hyper and just don't be stating any XYZ things which are not required. Okay, you have to stick to the rules. See the rules, read them carefully. If they state, your points would also be deducted if you state unnecessary things as well. Okay, so please read the rules and format it in that way only. Okay. You see what you're. So don't add unnecessary things. Don't make it messy for you. Okay. Anybody else? Okay.
Ma'am, what's the difference between citation and footnoting?
Okay, so citation is basically the case that you're citing. The citation would consist of basically the journal that you're referring to, the volume number, the page number, and the year. That is the citation. Footnoting is basically citation can be footnoting. Basically, in footnotes you can put the citation, but footnote is an expanded version. It can also consist of any law report. Also, it could consist of any book name. So how it has to be drafted, I can also just suggest you how it has to be drafted. So if you're referring to any book, okay, so how would you write the footnote of it? First, you'll write the name of the author, okay? Then you'll write the name of the book. Then you'll write the name of the publishing house and the year, okay? So in this way, you have to make your footnote very clear. So that it is understood to the reader that what you're stating. And footnoting, like where did you refer this particular paragraph or this particular thing from? So for that, footnoting is very important. Citation ka footnoting tab karte hain when we are mentioning a case. Okay, say I mentioned a case. Okay, so for that case, I'm citing it that when it was reported, as I explained to you, the law journal and the name. You can also mention the name of your case in the footnoting. Okay, and then the citation. Citation is the basically the explanation, the general and the year and the volume number and the page number of the particular case. I hope I'm clear. Anybody else?
Good afternoon, ma'am.
Hi, good afternoon.
Ma'am, my question was that whether to write the argument advance in the point format or in paragraph format.
Okay, see, it would come in paragraph format because it is the most detailed part of your memorial, right? So it cannot be in the whole point format, but it has to be segregated. Just do not state one argument and just be keep stating it like it is going and it is not even numbered properly and it is not even paragraph properly. Has to be in paragraph, cannot be in points, but the heading has to be properly done. So what you can do is you can use caps, right? You can bold it, you can underline it. Then you can use subheadings also. Make it look very neat and tidy. Just do not keep writing it and Do not keep proper spacing also, and break the paras also. Has to be in paras, but has to be broken also in between, so that it is very clear to the viewer. See, for example, if I write a paragraph consisting of, see, 15 lines, or say I consist of a paragraph that is of 5 lines. So I'm telling you, the reader would read the 5 lines and not the 15 lines. Okay. So kindly break your paras also to basically make it more visible, to make it more legible, and for the reader to make the reader want to read your arguments. Okay.
Thank you, ma'am.
You're welcome. Yes. Anybody else?
Ma'am, can you tell us any valid website from which we can find out valid formation of footnoting? Like in research paper, there is another kind of formatting for formatting in footnotes. So, is there any format in making memorial for footnoting?
So no, this question is not correct. Do not use any website for it. You have to use your own intellect for basically writing the footnoting. What website would you refer to? What I'm telling you, this is how the way it has to be done. Footnoting has to be done in a proper format. But for that, I cannot suggest you any website. It comes from research. It comes from proper. See, what you have to state in your footnote, it should basically explain your paragraph above, right? That consists of the footnoting. If there is any citation, for that, there's no website. See, you have to use journals. You can use, there are so many platforms. There is Manupatra, there is SCC Online, there is there is AIR, there is Law Finder. There are so many basically journals that you can refer to. There are books. You refer to books, and then you can basically reproduce the para of the book, and then in the footnote you can write the detail of the book, right? So I don't think any website would help you for it. You have to research.
So, ma'am, do they provide us any format in each mood competition? Do they provide us?
Yes. They can be also. Yeah, that's what I'm telling you. So, Garima, for that you really have to go through the problem as well as the rule book also. It is. I'm telling everybody here that it is not necessary that the way that I'm telling you how the memorial should be drafted. It should be drafted in that way. But the formatting and the spacing and the font size, it can be stated in the rules also. So please just don't blindly stick to any particular format. Okay, go by the rules. Firstly, go by the rules. If rules are silent on it, then you can use the general guidelines that I was also telling you. Okay, but then if there are any rules that are specifically mentioned, go by the rules. Otherwise, your marks will be deducted. Okay, and the way you're judged, your memorial also consists of a huge number of marks, right? So kindly do not make this mistake. Okay,
ma'am, but if no rule is provided in any
yes, then use the general rules now. Use the general footnoting that is there. See, there is a blue book sort of a format. You will find it. Okay, and then in that way you can write your footnoting. Okay.
Okay, ma'am. Thank you.
Okay. You're welcome. Yes. Anybody else? Then I think we'll wrap up then.
No, ma'am. Thank you, ma'am.
Okay. Thank you so much, everyone. Thank you for being such patient listeners, and I hope I was able to help each one of you with the drafting format. Yes. Anybody?
Excuse me.
Asking. Yes.
Actually, I have seen so many lawyers are keeping pens. Four colors are pen. So two colors you have already mentioned. One is for plaintiff and one is for defender. How about the other two colors?
Oh no. Okay, so I think you are mistaken by what I was stating. So for the MOOT memorial, what I was stating is that the cover page has to be in red color. Okay. For the defendant, it has to be in blue color for the appellant or the petitioner. The color of the page I was stating has to be blue or red. Okay. Now for the advocates, the pens that they are carrying. Okay. So this is a This is an okay extra question. Why not? Good question asked by you. So there are 3 pens basically that we carry generally. One is black, one is red, and one is blue. Okay. Why black? For anything that if we have to basically maybe correct any drafting. The drafting submitted by us before the courts is in black, right? It is printed. So if there is any mistake, so that is typed by us. Blue pen, why? For any signatures, for any other matter, for any other things. Blue pens are the most common. Why a red pen? Red pen is for marking exhibits, okay? So for that you'll be needing once you're graduated. Right now, it is not needed for you. But yes, whenever you enter the field, whenever you're litigating, whenever you become a lawyer, right? So keep these 3 pens with you, okay?
Thank you.
Okay, you're welcome.
Sorry to interrupt. We'll take the questions in further session. Thank you, ma'am, for sharing with
Okay,
us.
you're welcome. Okay, thank you.
Thank you, ma'am, for sharing with us such helpful advice and useful tips and tricks. It will definitely help us in our future. Now, I would request all the participants to switch on their cameras for capturing this moment. Now, I would request Ms. Palak Vashish ma'am to express a vote of thanks.
It's a privilege to present the vote of thanks for the session 3 of second RSLW MOOT training workshop. A memorial forms the base of any MOOT. You can't go beyond the memorial, but it is a well-drafted memorial that brings all the accolades. The drafting must be intelligent and coherent, as suggested by Ishita ma'am. I would express my heartfelt gratitude to our guest speaker, Ms. Ishita Rawat, for sharing her knowledge with all the participants. Thank you, ma'am. Our profound thank you to Principal Ma'am Dr. Vartika Arora for always being a beacon of guidance, motivation for all of us. I would also thank all the volunteers, organizing team for the efforts behind the scenes. Our gratitude to our technical staff, especially Mr. Pawan Sharma, for all his contribution. Thank you all for joining. Thank you.
Thank you. Thank you so much.
Now, I would request all the participants to please fill up the feedback form.
Naz,
Yes, ma'am?
is the guest speaker here?
Yes, ma'am.
I guess she has left.
She has left.
Ishita ma'am. Anyways, the session went well, and thanks to everyone. One thanks to Palak ma'am for proposing this vote of thanks. Thank you, Naz, and thank you, Ishita ma'am.
Thank you, ma'am. The next session will start at 1:30, which you can join by the link, which will be provided on WhatsApp group. Thank you all for joining the session with so much zeal. See you in next session.